Hello to everyone. I wanted to jump on today and check in with some upcoming due dates and some reminders, talk to you a little bit about some of the kinds of questions that might appear on your next exam. For starters, your next case study is due on on Saturday the 23rd, along with your next discussion board. If you have any questions about the case study, feel free to reach out and let me know via email. Um, Additionally, don't forget that your project will be due later on down the semester. The PowerPoint slide where you're working with a case and putting together a presentation either from the perspective or defense based on your last name. So if you haven't looked over that project, I do recommend jumping on there and starting to think about it a little bit as you continue to work through the content this semester. And then next up, this chapter, chapter 7, deals with the pretrial and trial process. Frequently, this is a little bit murky, and so I would strongly recommend that you take note cards and write out the process and mix it up and try and sequence it. So just something small like this blue piece of paper that says arrest, and then have one that says booking, one that says initial appearance, and kind of be able to sequence it. Because you will see some sequencing type questions appear on your next test. They won't have all of the steps in the process, but they will have some steps and you will be asked to put them in order. So in preparation for that, I would definitely encourage some type of studying technique that would enable you to sequence the pretrial and trial processes. Also, that doesn't mean that you can ignore the terminology or the timeline, because those types of questions may still appear in other capacities. So if you have any questions about that, feel free to let me know. Running through the process fairly quickly, the first step of the process is the arrest. This is generally a police officer arresting a criminal suspect, taking them into custody. After the arrest occurs, the individual will be booked. This is an administrative procedure that still occurs in the police station. It involves getting personal information from the offender, as well as inventorying all their possessions and things like that. After being booked, the defendant will make an initial appearance before a magistrate or another judicial official. They will be advised of the charges against them, and they may even determine bail at this initial hearing. But this usually tends to, depending on where you live, it needs to occur 24 to 78 hours upon being arrested. Next up is bail. If bail is going to happen, it is decided by the judge or magistrate. They usually look at your ties to the community, whether you are a threat to yourself or others, whether you might flee the jurisdiction and your resources. If you are a low-level threat, you have strong ties to the community, you may be released on your own recognizance, which means nothing put down. If you might flee or you have no strong ties to the community, you might have to pay a bail, with the thought that this will ensure your appearance throughout the rest of the process. Next up is a preliminary hearing. This occurs after you've been arrested and had your initial appearance, and the goal is to determine whether probable cause exists. This only happens on the state level by and large, because on the federal level, the grand jury will determine if probable cause exists. So when the prosecutor issues the charges themselves, the magistrate or judge will determine if probable cause exists. If probable cause is lacking, the case will stop. Okay? And on the federal level, we will have the grand jury who will issue either a true bill or no bill. If a true bill is issued, the defendant will move on to the arraignment. Okay. At the arraignment, the defendant is informed of all the charges against them, the possible punishments, and then they enter a plea of guilty, not guilty, or no contest, nolo contendere. Nolo contendere is usually reserved for situations where the defendant might face some civil liability from their actions and they want to protest that civil action. So it still ends the criminal case, but they are not actually entering a guilty plea. It is the defendant's right to determine whether or not they are going to have a jury trial or a bench trial. If the defendant chooses the jury trial, then we'll have the jury trial, and the jury will determine who will determine the facts of the case. The trial process itself, so far we've talked about an arrest, a booking, an initial appearance, a preliminary hearing, and an arraignment. Next, if the defendant pleads not guilty at that arraignment, the case is scheduled for a jury trial or a bench trial. Before then, we might have some motions back and forth to limit or exclude evidence. And then once the trial process starts, it looks like this. It begins with opening statements. The prosecutor goes first, and the defense attorney goes second. Then the state presents its case. They will present witnesses. They will then direct examine all of their witnesses. The defense will have the right to cross-examine all witnesses and try to diminish culpability or responsiveness for the witness. As far as impeach, on cross-examination, you can just call into question the truthfulness or credibility of the witness. So if the witness gave an affidavit where they said one thing and now under oath they're saying something else, we could point that out to diminish their credibility. We can also discuss issues like, did the witness need a hearing aid? Were they wearing their hearing aid? If not, why should we give you the same weight? So the evidence is still admissible, and it's up to the jury to make that determination. Well, how credible do we find this witness who heard something without their hearing aid? Okay. At the end of the state's case, the defense then engages in calling their own witnesses if they so choose. The defense will direct examine their witness, and the prosecution will have the ability to cross-examine. At the conclusion of all of the evidence, the defense will usually ask for directed verdict to acquit. Those are almost never granted. At that point, the judge will issue instructions to the jury both on procedures and on the law. Then the jury will begin to deliberate. This is when the jury retires to their room, considers the evidence, and hopefully arrives at a verdict. If the jury cannot progress towards a consensus, the judge may give them more instructions, and ultimately, after the jury retires to that room, either we will have a hung jury who cannot agree, or the jury will return a verdict of guilty or not guilty. And we'll go ahead and note in some areas that jurors do not need to be unanimous. In other places they do. It depends on where you are. So in the event that a guilty verdict is issued, then the defense will ask for the judge to set the verdict aside. That really doesn't happen very often. And after that, we would move to sentencing. Sentencing is separate because we generally, a pre-sentence report is prepared that looks at specific issues like past criminal history, and will help the judge make a recommendation for how long this defendant should receive. Now, if the verdict comes back not guilty, the trial is over and the defendant has been acquitted, and they cannot be charged with those same charges against them again. So the process kind of runs through, if we're going to run through it one more time, arrest, booking, initial appearance, preliminary hearings, arraignments, and then we would move towards the trial process, um, which would begin with opening statements, then witnesses that are going to be direct examined and cross-examined by the person who asked them. Um, After that, um, the judge will issue instructions on procedure and instructions on the case. Then the jury will deliberate and return a verdict. If the verdict is not guilty, the defendant is acquitted. If the verdict is guilty, then the case will be set for sentencing. And so Chapter 8 deals more with either plea bargains and sentencing issues. So we'll talk about that some and look at that some next week. If you have any questions about the upcoming assignments, the upcoming due dates, or the kind of the sequence or what these terms mean, please feel free to reach out for me. I'd also like to take a moment to say thanks for all the good work you're doing. The quality that you have been turning into class has been excellent, and I'm really pleased with the way this class is going. So if you have any concerns, let me know. Otherwise, I hope you have a great rest of your day.